So in this video we are going to discuss about the law UGC Net 2015 paper 2. The first question is, match the list 1 with list 2 under the Hindu Marriage Act 1955 and give the correct answer with the help of the code given below. So list 1 contain A. Monogamy. The answer for this is section 13B. Judicial separation, section 11. Void marriage comes under section 10 of Hindu Marriage Act. Divorce by mutual consent come under section 5 of Hindu Marriage Act. So the correct option for this question is option 4. Question number 22. Which of the following are fault ground of divorce under Hindu Marriage Act 1955? So which are the grounds? Extramarital sex is a ground for divorce. Consent obtained by force or fraud is a ground for divorce. Desertion is also ground for divorce. Conversion to non-Hindu religion is not a ground for divorce. So correct option will be first. A, B and C are ground for divorce. Question number 23. A Muslim male is prohibited from marrying the following relations. So Muslim male cannot marry to these relations. Mother, grandmother, how high soever. He cannot marry to mother and grandmother. Daughter, granddaughter. He cannot also marry a daughter and granddaughter. Aunt, grand aunt. He can marry with aunt and grand aunt. Nizi and grand nizi. We call it as a bhatiji in Hindi. So he cannot marry with nizi and grand nizi. So the correct option will be A, B and D. D, B, A. Option 2 is a correct answer. Question 24. The dissolution of Muslim Marriage Act 1939 make available the following ground of divorce to a Muslim woman married under a Muslim law. So the availability of a ground where a Muslim woman can marry under a Muslim law. 7-year imprisonment of the husband. No maintenance by husband for 2 years. Whereabouts of the husband are not known for the period of 4 years. Failure of husband to perform the marital obligation for the period of 3 years. So the correct option is option first, C, B and D. These are the ground for a woman to marry under Muslim law. The correct option is option 1. Question number 25. The ancient source of Hindu law includes. So what are the source of Hindu law? Ancient source of Hindu law. Shruti, Smriti, custom, digest and commentaries. So the correct answer is A, B and D. Custom is not ancient source of Hindu law. So the option 2 is correct. D, A and B. Shruti, Smritis and digest and commentaries. Originally under the Hindu Marriage Act 1955, divorce was based on fault theory only, breakout theory, consent theory, fault and consent theory. So the correct option is fault and consent theory. This was base of a divorce in Hindu Marriage Act 1955. Question number 27. A grocer supplier goods wrote 6,000 on credit to A. In addition, the grocer solicited a donation of ₹2,000 for his son's education, to which A consented. A later refused to pay both sums as he lost money on stock transaction. Which one of the following is correct while deciding the liability of A? Option A. A has already availed of the benefit in terms of goods supplies. Hence, consideration between the two bind A to pay. B. A is not bounded to pay 2,000 as it is a gift which is not enforceable in law. Option C. A is liable to pay both sums as it is promised between A and grocer. D. A is not liable to pay either of sum of as both of them are joint and not separate. So the correct option is option A and C. Option 2 is correct answer at he has to pay both the amount as A mentioned. A has already availed the benefit in terms of goods supply Hence, the consideration between the two bind A to pay the liability of 6,000, and A is also liable to pay both of sum as it is promised between A and grocer. So option 2 is correct. Next question 28. X makes an offer to Y. X die the next day, but Y does not know of the death. Y send a communication to the address of the X accepting the offer. In the agreement formed between the party, choose the correct answer. So in this situation, X has make the offer to Y, but next day X die, but Y was unknown of his death. Y send a communication notice of acceptance to his address. In this situation, option A, requirement of the offer followed by the acceptance are met. Absence of the knowledge of death will not invalidate the agreement. No meeting of mind which does not render it to an agreement. Death of the offer reduce it to nullity. So the correct option is option B and option D. Absence of knowledge of death will not invalidate the agreement, but at the same time death of the offer reduce it to the nullity. The correct option is option 4. Question number 29. Match the item of group A with those of group B and choose the correct answer using the code. So group A contain all the cases and group B for what basis the cases are done. Group A. First, Food Corporation of India versus Ram Keshav Yadav. So, this case was regarding impossibility of performance. Kedarnath Bhattacharya versus Gori Mohammed. This case was regarding capacity of minor to enter into contract. K. Balakrishna versus K. Kamalam. This case was regarding offer and acceptance. Satyabharata Ghosh versus Mugniram and Company. This case was regarding consideration. So the correct option for this will be option number 4. Last question is question number 30. Agreement without consideration is valid under Indian law amongst the following statement. Choose one which is against the law. So we have to choose that one which is against the law. When agreement written exists on account of natural love and affection. When the correct option is when the consideration is too inadequate. When the consideration is past one. When the consideration is from third party. So correct option is option 2. When the consideration is too inadequate, it is against the law. So this was the last question. Thank you for watching the video.